A very good morning and welcome to The Print Live this morning. We are live from the Supreme Court of India, in which in about 1.5 hours, a 5-judge constitution bench will deliver the momentous and historic verdict in the Ayodhya title dispute case. Just to give the viewers a quick recap as you join The Print Live, for the last 40 days, the key parties to the case, whether it's the Sunni Waqf Board, Ram Lalla Virajman or Lord Ram or Ram Janambhoomi Nyas, for as to say the Hindu parties, have really put forward certain strong arguments. But why at all did the argument take place in the top court is the first question. Let's take you back to 2010 Allahabad High Court verdict, when a 3-judge bench had ruled that the land in dispute, the 2.77-acre land in Ayodhya, would be divided equally among the 3 key contesting parties. That's Ram Lalla Virajman, Sunni Waqf Board and Nirmohi Akhada. Just to give you small brief intros about each of the party. Ram Lalla Virajman, or Lord Ram, became a party to the case later, since the verdict was instituted in Faizabad District Court way back in the early 1800s or the late 1800s, for us to say. When Lord Ram became a party to the suit, it became a 3-way division of the suit. On one side was the Sunni Waqf Board, who claimed that this land is the place of the Babri Masjid, which was built way back in the 15th century. And in fact, no temple was demolished to build the temple at the disputed site, and hence when a place has a mosque there built, then that place belongs to a mosque forever and the prayers are entitled to be prayed there. When Ram Lalla Virajman argued before the court, the key argument on behalf of Ram Lalla Virajman was that this entire land is of a juristic entity. This entire land belongs to the spirit of Lord Ram. The key argument in this case was, it does not matter where Lord Ram has exactly taken birth, whether it's under the Ram Chabutra, which was inside the mosque area, or it was outside. The main contention was the entire 2.77 acre of the land was an extremely holy site for the Hindus. Another key argument on behalf of the Hindu parties was that this site of Ram Janambhoomi, for according to them, is as holy to them as Mecca is for the Muslims. So the key argument on their behalf was, can the Kaaba be shifted from the Mecca? The answer is no. And similarly, the Ram Janambhoomi cannot be shifted from the disputed site also. When we go to Nirmohi Akhada basically was a fighting for Shabaitship rights. Shabaitship rights is essentially worshipping rights of Lord Ram, and their key contention was, since they have worshipped Ram for centuries, they automatically have the ownership and guardianship rights of the land. It is going to be a very thin walk on the ice for the 5-judge constitution bench. The rumors are galore how the verdict would turn out to be, but however, at The Print, we would advise caution against any of such rumor mongering that is taking place at the moment. We also have to know that this entire dispute is a title dispute case. A title dispute case is essentially about who owns the land. Who owns the land? Who owns the land from where the Babri Masjid was built way back in 1528? The court will have to see whether faith triumphs evidence. Now, when we come to evidence part, we also have to look at what was submitted by the Archaeological Survey of India. The ASI report categorically mentions about how a massive temple structure indeed existed beneath the mosque structure. However, the Muslim parties had categorically argued that the massive structure that was there beneath, as submitted by the ASI report, had pillar bases at different levels, and however and they went on to argue in the court that is why the ASI report was cannot be relied upon to justify the fact that there indeed was a temple before the mosque was demolished. We have a couple of questions coming in as to what time the verdict will be out. Mehul, the verdict will be out around 10:30 a.m. Let's be very practical here. When there's such a big verdict as supposed to be announced, there are quite a few probabilities that take place in the verdict. It could be a unanimous verdict. It could be a verdict which is 3:2, where the 3 judges support in majority and the 2 judges rule in dissent. It could be 4:1, where the 4 judges rule in majority and 1 judge rule in dissent. It could also be a unanimous verdict, as I pointed out earlier. So when such verdicts are delivered, it just takes some time for the court to actually read out the entire verdict, because if you remember, when it was right to privacy privacy. It was a unanimous verdict by the 9-judge bench, and since it was a unanimous verdict, the verdict delivery did not take much of a time. It was delivered in about 2 to 5 minutes because the Chief Justice at that point of time just read out the key operative part that we hold right to privacy as a fundamental, a right to life. But in this case, there's a possibility, there's a thin possibility that there could be multiple. It takes some time. However, in case of a unanimous verdict, again, it would take some Ayodhya land dispute because the court has to answer each and every question. The mosque was built by demolishing a temple. Second was whether at all this land belongs to Ram Lalla Virajman and they accept it as a juristic entity. And third was, and the key question was, whether the Allahabad High Court was correct in dividing the land into, if that is what is going to happen in the Supreme Court today, then indeed it is a just. And if that happens, then indeed that again would be a landmark decision, because if we recollect the earlier reports by ThePrint, the Chief Justice of India, Ram Janambhoomi-Babri, while hearing the case, always told the litigating parties and their counsels that the court is going to strict dispute on. Forget that the 5-judge bench had reminded the then advocate on behalf of the Muslim parties that these evidentiary mechanism at the top court is a little bit different, because evidence taking happens at the lower courts, and it is the first step how the evidence has to be taken. Question coming, there were all the appeals were from the litigating parties, and they were bunched together in one single case here, because if you remember, after the 2010 verdict was delivered, single case here, because if you remember, after the 2010 verdict was delivered, none of the parties had accepted the verdict. Now, there are times and there are situations when the parties, if there are 5 parties, 3 agree to a verdict and 2 doesn't, and they appeal. But in this case, all of the parties had appealed to the court because none of them had prayed for a 3-way division. Let's remember the key point in law when parties go on to appeal, that the court has gone out of bound in giving a judge he had prayed before the court, and that was also a clear question before the Supreme Court this time, that whether Allahabad High Court indeed overstepped its limit by giving a 3-way division of land and not ruling where does the land actually belong to, whether it's the Hindus or the Muslims. We have a question coming in from Mr. Parshvanath. Will there be riots or a scene of violence in the country? What are the steps taken to prevent violence? Mr. Nath, it's a very pertinent question actually. If you remember, after the demolition of the Babri Masjid, there were certain riots which had damaged the secular fabric of the country. Whether it be the Mumbai riots or the Gujarat riots, it probably, those couple of years have charred our memory. Whoever have been a part of that history, and that has also remained an intrinsic part of India's political discourse ever since. However, if you remember, after the 2010 verdict of the Allahabad High Court, the riot scene was not that prominent because of the 3-way division of land. However, yesterday when the Chief Justice of India met the Director General of Police and the State Special Secretary of Uttar Pradesh, there were murmurs that why is the Chief Justice of India going? A judiciary is never supposed to take extrajudicial information before delivering a verdict, but here the Chief Justice has done just that, and a day after the meeting he is delivering the verdict. So there were talks that the verdict could lead to a potential law and order problem, but also let's remember that all the state governments have deployed additional paramilitary forces. The Home Ministry has issued directives. In the Supreme Court itself, there is a heavy police deployment at the moment. All the roads have been barricaded. A strict entry into the court for only people who are holding the court passes. In Ayodhya, roads leading to the disputed site have already been blocked. There is a media cell which has been set up in Faizabad, which is at a really good distance from Ayodhya. So we have to understand that the security arrangements are top notch in the country at the moment. But one factor which might dampen your spirits is social media. So we at ThePrint would also like to caution all the members of social media to take to tweeting, to take to Facebook posts, and to take to Instagram and YouTube posts a little lightly and not disturb the communal sentiments of the country, essentially, since it's a very sensitive matter, and also follow ThePrint for all authentic updates. Now we have a question from Mr. Pawan Kumar. Can the case be taken to court when both sides are not satisfied? Of course, Mr. Kumar, that is one of the grounds of the appeal. When both sides are not satisfied with the decision, it has to be taken to the court. But if your question a little differently. You're also asking me whether at all, there is another way of hope if the parties are not satisfied with the verdict which is being delivered by the top court today. So let me just answer you in brief. Yes, there are two ways: review petition and curative petition. After the 5-judge bench of the Constitution bench rules in favor of any of the parties, or proposes a solution, etc., we must not forget that there are alternate remedies available to the parties also, in which the verdict could go in for a review or a curative after the review has been dismissed, of course. But again, let's remember that review petitions in this case would again take a lot of time, because this particular case in the Supreme Court itself has been in the cold storage for over 8 years, and it's all started from 2011, since a stay in the Allahabad High Court was granted by the top court, and ever since then there have been continuous hearings in the Supreme Court where benches were the case. However, there were multiple issues, starting from the transcript translations, then going forward to bench allocation. Ayodhya indeed had a lot of hurdles, then going forward to bench allocation. Ayodhya indeed had a lot of hurdles in the Supreme Court to come to this day when the Constitution bench is delivering a verdict. So if in case we go for a review verdict, it's going to be a momentous time-taking process in the higher judiciary. Now we have a question from Mr. Nikhil Nair, who says, is there a special arrangements of security regarding this verdict? I think I was answering to Mr. Parshvanath, is there a special arrangements of security regarding this verdict? I think I was answering to Mr. Parshvanath when we clarified about this particular pertinent point raised by you, that indeed the security arrangements are top-notch, whether it's in Uttar Pradesh or Delhi or the neighboring states, where even in Bangalore, etc., schools and colleges have been shut down in light of the Ayodhya verdict. It has also been said that social media accounts particularly of civilians who are going to tweet about inflammatory stuff is going to be taken note of. If you remember, there's the famous author Rana Ayub made a tweet last evening about how the Babri Masjid was demolished and how this verdict is going to test the secular fabric of the country, and immediately the first comment was from the Amethi police, who said that this tweet is communal in nature and hence you have to take it down. So this itself shows that the police is also very much vigilant and present in the social media accounts of the civilians, authors or noted personalities. So that might help in putting a check to any kind of riots or violence in the country. But let's remember that in political discourse, in communication, in conversations and in the social media. Sukhi is saying, why was the verdict preponed? Sukhi, I'm quite not sure of the question, because the verdict had never a particular date when it would be announced, because verdicts don't have date until the last evening of it is being announced. There is something in the legal parlance known as the cause list, and cause list really lists down the matters that are going to come up tomorrow, either for judgment or for hearing. And this particular notice of Ayodhya verdict was put out last evening at about 9 p.m. in the Supreme Court website, and before that there was no there were no dates as to when the verdict would be out, and hence there is no question of preponement. Yes, the question could be why Chief Justice of India indeed selected Saturday to be the day of verdict, but let's not forget Saturday has been the day for Chief Justice of India Ram Janambhoomi, because Ayodhya case was heard on Saturday, so that it could be wrapped up in a speedy manner. In fact, when there was a sexual harassment allegation against Chief Justice of India Ranjan Gogoi, and he heard his own case in the top court, that case was also heard on a Saturday. So a verdict on a Saturday is also after discussions with the security personnel, etc. So let's just wait for what the verdict has to say. Bhavya Kama says, can SC dismiss the review petition it filed after the verdict? Bhavya, I think we are in one way or the other counting the eggs before they are hatched, because I think after this verdict today, it has to be seen what the verdict entails, because it's certainly going to be a very lengthy judgment, that's for sure. Even if we don't know what's going to be there in the verdict, who's going to be favored and who's going to win in the case, one thing is for sure, that it's going to be a very lengthy judgment. So after this judgment is there, all the legal experts of all the parties concerned will peruse over the judgment, and even if one person feels that the judgment is not to their liking, they can approach the top court. Even one disgruntled party can approach the top court to seek remedy and to seek review of the decision. Of course, it depends on the top court to dismiss the review or fix up a higher bench to hear the case. And let's not forget that when a 5-judge bench hears a case, it has often been seen that in review a 9-judge or 11-judge bench hears the case. So we really don't know if that's the way ahead for the Ayodhya title dispute case. But as of now, we have to just wait for about, say, 1 hour to see what the top court holds in this case. Dhananjay says, do you think Rana Ayub was bashed for the wrong reasons? Does her tweet come under the umbrella of provocative comments? And now, Mr. Dhananjay, the centre is yet to notify next would be seen. However, the Amethi police's observation also shows that any kind of tweet which remembers the demolition of the mosque or which tries to fan communal sentiments to the demolition, you cannot show any kind of visuals about the demolition of the mosque. So I presume that the police has drawn the reference of the tweet being violative of social media rules from that directive of the police. We have questions coming in for the live. If you have more questions, do send us in, because the print has to get inside the courtroom to get you authentic live coverage of the verdict in our live blog. And we also have to remember one. But at several points, Chief Justice of India Ranjan Gogoi had made a point that at no time can the verdict be delayed. At no point can the hearing be delayed. I still remember in the court when the Chief Justice who impleaded in the Ayodhya title dispute case, which was essentially between key litigant parties of 3 or 4 parties in total. But however, it soon became 16 or 17 parties in total in the Ayodhya dispute case, especially when parties like Hindu Mahasabha, etc. tried to implead their applications and argue before the court. But it was only Chief Justice of India's wit which did not allow the case to drag beyond a certain time limit. Now, I think that's a wrap up from us here at The Print from the Supreme Court lawns, when we get inside the court to get you the live coverage of what happens and what the 5-judge bench actually rules in the Ayodhya title dispute case, which have been pending for over a century. This was Debayan Roy for The Print. Stay tuned to our live blog site on our print website for all the latest updates and coverage. Please subscribe to our YouTube channel for videos and also latest updates on the Ayodhya verdict case. Thank you and see you again.